So moving along, we mentioned the contracts that are annexed to the FDD. The most important, the most critical document is going to be the franchise agreement. As I mentioned, this is going to overlap with the FDD, but except for the franchise agreement is the binding document. This is the contract that both the franchisor and the franchisee sign. This is going to lay out all of the franchisee's obligations. This is going to give the franchisor tools to enforce their obligations. And typically it's going to lay out the franchisor's obligation, at least with respect to its obligations related to support and training. Those obligations are going to be in the franchisor's discretion. So these are typically pretty franchisor-friendly documents. This is also where this is a great place to have that conversation with your client about their future plans for growth. So you can provide for some flexibility here. You want to reserve the right in the franchise agreement for your client to say, for example, acquire competing systems, be acquired by another system, to merge with another system. So you really want to have that conversation with your client. What are their plans for growth down the road, and how am I going to facilitate that in the franchise agreement? And make sure that you've done that very specifically. We're seeing more and more franchisors include that language.
So what Mackenzie mentioned before is that item 21, I think it is, of an FDD.
Yeah.
Nope, I'm sorry. Item 22 is a list of the agreements that are attached to the franchise disclosure document. In addition to the franchise agreement, we do the documents that are listed in the next slide.
Oh, there we go.
So we always have a separate confidentiality agreement and non-compete agreement. Although these concepts are addressed in the franchise agreement itself, we typically want to have that in a separate document. It sometimes eases enforcement with judges who want to just see the main document, not look at a 60-page document or 70-page document. When we're involved in litigation, we point to the separately executed confidentiality agreement and non-compete.